thank you everyone for joining us today for our presentation on the National Interest Waiver, or NIW Green Card option. My name is Dustin Saldarriaga, and I'm a Senior Associate with Scott Legal PC here in New York City. I'm joined today by my colleague, fellow Senior Associate G.A. Huang. G.A. has extensive experience preparing NIW petitions, particularly complex petitions. So we're very fortunate to have GA joining us today. GA is going to present the first half of the presentation, and then you'll be hearing from me again in the second half. A few things before we get started. This webinar is part of a series. We try to do, at this point, I think 2 webinars a week at least. They cover a range of U.S. immigration options, from the national interest waiver and green card options to temporary entrepreneur options like the E-2, to student visas, family-based green cards, litigation. Really, we run the full spectrum. And that reflects the services that our firm offers. So we really do hope that if you have any questions about U.S. immigration, please reach out to us. Please schedule a consultation. We'd be happy to talk with you. After this presentation, you'll be getting an email with a link where you can schedule a consultation. That email will also have a link to our YouTube channel. We record the full-length webinars. We'll be recording this webinar, and we post these recordings to our YouTube channel, so you can check out our past webinars on a variety of topics. We also post to our YouTube channel shorter videos, so check those out as well. And we also have a very active blog, so that email you'll get will also have a link to our blog. I think we have thousands of posts at this point. We really try to address the questions that have come up as we've been preparing these petitions over a decade, over more than a decade at this point. So we hope that's useful to you. We'll also send you a copy of this webinar, the PowerPoint that you see on your screen. So no need to take extensive notes. That email will also have a link where you can sign up for future webinars. So we hope that you will do that, and we'll see you on future webinars. If you have a question during this presentation, please use the chat function or the Q&A function on Zoom. We will be monitoring questions. We plan to get to all the questions by the end of the presentation. We'll probably save questions for the end, but don't let that stop you. Please do send your question in, and we will plan to get to it. All right, without further ado, I'm going to go ahead and pass it off to GA to talk about the National Interest Waiver.
Thank you, Dustin. Welcome, everyone. Thank you for joining us today, this morning. So let's talk generally about what really is an NIW. What is a national interest waiver? When we speak of waivers, what are we waiving? So the EB2 NIW is a green card option. So if you succeed in an EB2 NIW petition, you would get the ability to apply for a green card through either, an immigrant visa, or if you're already in the United States in a different non-immigrant status, you can also apply for a green card within the United States with filing the I-485, the Adjustment of Status petition. Now, the special thing about the EB2 NIW is that if you qualify, you don't need a U.S. job offer to drive forward the petition. The foreign national himself or herself can drive forward the petition, can file the petition as a self-petitioning mechanism. You don't need a U.S. job offer, and that can be quite a bit of an advantage for many reasons. One of the reasons is that for the ordinary, labor certification pathway, which is, the larger EB2 category. So if you have an advanced degree or exceptional ability, another way you can get the green card is by getting a U.S. employer to basically sponsor you, right? And that is, the ordinary mechanism. However, sponsoring a foreign national for a green card, the employer needs to go through quite a bit of a costly and time-consuming process to really test the labor market in the United States and to prove to the government that there is no one else in the United States who is minimally qualified to basically fill that position among U.S. citizens. And only after the employer can prove that are they able to sponsor a foreign national for that particular position to fill that job. So it takes many years, really, with, the elongating processing times with the Department of Labor, with the PERM program. Really, this can be a multi-year process to sponsor for a green card. But if your case qualifies for an EB2 NIW, you are exempt from that process. You get a waiver of that process such that you don't need a U.S. job offer. You don't need a U.S. employer to go through that process. Instead, you can self-petition for a green card, shaving off many years in the lengthy process for a green card. So, the NIW is a green card option that can be available when the government concludes that you're coming to the United States to do something that is in the national interest. And national interest is the key here. If your case serves the national interest, then the government may grant you a waiver from the labor certification requirement, which is ordinarily imposed. Now, as I mentioned briefly, the NIW is a subset of the larger EB2 employment-based green card category, but it has a much higher bar than the perm-based company sponsorship. If the company is sponsoring you, basically, the main qualification that you need to prove is that first you're qualified for the job, but also that there is no other U.S. person that is available to fill that job, and the company takes care of that. However, if you're self-filing for an EB2 NIW green card, you need to instead prove that why your case merits an exemption. And for that, you need to prove that your particular case is in the U.S. national interest. And we will go a little bit further detail about what that means and how to prove that. But that is the extra burden that petitioners have when they are electing to self-file under the EB2 NIW category. So, the NIW eligibility criteria is laid out in a three-part requirement test, and it is based on a recent AAO case from 2016. It's called Matter of Dhanasar, and in addition to meeting the three-prong Dhanasar test, you must also provide proof that you meet the EB2 threshold requirement, which is either that you have an advanced degree in your field or that you have exceptional ability in your field. And we'll go over in the next slides in a little bit more detail about what that means. So the important thing to note here is that you do not need a U.S. employer to apply for a green card under the EB2 NIW category, which is one of the reasons why it is so popular and a very coveted classification, if you are able to convince the government that your case merits a waiver. And that is, I think, the challenge. However, there are strategies to really strengthen your profile and really strengthen how we present your qualifications to, increase your chances that you could be able to convince the government that your case is indeed within the national interest. So the waiver relates to the EB2 requirement, the general EB2 labor certification requirement to prove that a U.S. employer cannot find a qualified U.S. worker. But the challenge for the NIW is proving why your case merits an exemption from the ordinary requirements of a job offer and labor certification in the national interest. And usually, you emphasize the broad systemic impact your work can have to your field in terms of advancing best practices, knowledge dissemination, technological advancement, and the like. And also, you can point to some of your unique qualifications that cannot easily be replaced by a U.S. worker with minimum credentials. And in the case of entrepreneurs, if your particular business project will provide a substantial economic benefit to the region that is significant with respect to the population and circumstances of a region, that can also be a strong argument to support the national interest argument. And finally, one important thing to note here is that contrary to, some popular, understanding that maybe is NIW only, related to STEM fields? And the answer to that is no, actually, applicants in any field can apply. There is no limitation on the type of field or area of profession where an NIW applicant can prove a case of national importance. You could be a lawyer and have, made or will be making significant advancements to how legal professionals approach a particular area of practice. And maybe you can say that has large enough impact to, kind of advance the envelope of a field and have broader impact to the field, and maybe that can, support an EB2 NIW case. You can be someone in the humanities and really be proposing an endeavor that will significantly advance cultural enrichment of the country, really transform the way that a particular, art form is, being explored. So really, there is no limit on the type of field where you can apply for an NIW. And conversely, there really is no inherent advantage. Well, maybe there is a little bit, but really, really not really an inherent advantage of even if you're in the STEM field, right? If your work will only tend to benefit your immediate employer or your immediate clients, if you're only applying existing methodologies, for the benefit of your immediate clients, and if that is kind of a localized benefit there, you may be having a hard time convincing the government that your work will have that broad impact that is expected in a national interest waiver petition. So really the point to drive home here is that the specific proposed endeavor is important, not necessarily the applicant's field. So really you need to think more about where to, place a focus when you're assessing and preparing an NIW case, not necessarily about the importance of the field, but really is the importance of what you're doing to the field. So that is definitely a nuanced distinction, but an important one, especially as adjudication standards are tightening across this field. All right, so we'll move on to the next slide. So let's talk a little bit more about the threshold requirements. So in order to file a successful EB2 NIW petition, you need to make sure that you meet the threshold requirement applicable to all EB2 petitions in that category. So either if you do, a perm-based petition or an NIW-based petition, the threshold requirement must be met by either showing that you have an advanced degree or that you have exceptional ability in the sciences, arts, or business in your field. And so, and there are different ways to be considered an advanced degree professional. So you can just have the degree, so a master's degree or a PhD degree, or even a degree like a JD or MD, where you would need a bachelor's degree to gain admission to that kind of program. So you can show that you have the degree. Now, one thing to note is that if your degree is from a foreign institution that's out from outside the United States, you do need to also get a education equivalency report from an agency in the US that would assess the particular type of degree that you have from the foreign institution and provide a report with citations of how that is equivalent to a master's level degree in the US context. So you do need that report to prove that to prove the equivalency. Now, if you have a bachelor's degree in your field, and if you have more than 5 years of full-time progressive work experience in the profession after you had received your bachelor's degree, you may be able to prove that you have the equivalent of a master's degree. So if you have that bachelor's degree and the 5+ years of progressive work experience, you don't need to go through the exceptional ability criteria, because you'll be able to qualify under the advanced degree rubric. So one thing to note here is that the bachelor's degree and the progressive work experience must match in terms of the area, right? And they also must be directly related to your proposed endeavor. So if you, have a bachelor's degree in engineering, the work experience must also be in engineering, and your proposed endeavor must also relate to engineering in order to, have that continuity. It won't really work very well if, for example, you have the degree in engineering and you have the work experience in engineering, and then you're, proposing to be a baker or, something like that. That may unfortunately not work. So there definitely needs to be that consistency across the board when you're meeting the threshold requirement. Now, one thing to note here is that the operative word is progressive. So when you are trying to meet the advanced degree threshold with a bachelor's degree and progressive work experience, you need to make sure that you have the appropriate employment confirmation letters from your previous employers. And the employment confirmation letters from your previous employers must be detailed enough to show the government that your job duties have changed over time and increased in complexity and increased in seniority with respect to the responsibilities that you had to justify that upward trajectory when we're speaking of progressive work experience. If your job duties stayed the same over time, even if you've worked, more than 5 years, you would have trouble proving that your work experience was progressive. So definitely that is a strategic detail to note. Now, let's say you don't have a master's degree, you don't have a bachelor's degree, or maybe you don't have the required 5 years of progressive work experience in your field. Then how else can you qualify for the EB2 threshold requirement? You can show that you have exceptional ability in the sciences, arts, or business by showing at least 3 out of the 7 criteria listed here. Now, it is important to note that exceptional ability is a lower standard than extraordinary ability that we commonly talk about in the EB1A context. It is an easier standard to meet, but still, the operative language is that you must be able to show that you are someone who is operating at a level that is significantly above what is ordinarily encountered in the field. So you don't need to show that you are the very best of the best, the cream of the crop, the small percentage that are risen to the very top of the field as required in EB1A context, but you still need to show that you're distinguished as compared to the average in your field. So, thinking of criteria such as recognition for your achievements and significant contributions to your industry or field by your peers, government entities, professional or business organizations, can be very important to provide that level of, volume of evidence that in totality the government will, conclude that you are indeed someone who is pretty much significantly above the average. So that's the operative language that you're looking for. Okay. So now, once you have met the EB2 threshold, the next challenge is really to demonstrate to the government proactively that your case merits a national interest waiver. And that is really the main challenge of an EB2 NIW case to really convince the government why your case is so special that you don't need to go through the ordinary labor certification requirement, the ordinary job offer requirement. Because of XYZ. And so the criteria that you need to prove to support a national interest waiver claim are threefold. It is a three-prong test promulgated by Matter of Dhanasar. So let's go through the three prongs one by one. So the first requirement is that the applicant's proposed endeavor must have substantial merit and national importance. So, and let's unpack what that really means, substantial merit and national importance. Step one in the NIW process is to clearly define the endeavor. And more, the adjudication trend is that the government is looking at applications more closely to really see if the proposed endeavor is presented with enough specificity to even allow the government to assess what is the prospective impact of that endeavor. So it is very important to note that you need to present a specific project or goal that goes beyond simply working in an occupation. So as an example, if you simply say, oh, I am an AI engineer and I would like to continue working at Google. And if that's it, then unfortunately the government is going to say, oh, well, okay, well, that's not enough to present a proposed endeavor to me, right? And the reason why is because if the endeavor just ends at simply working in an occupation, the government is going to say, well, that's why we have the labor certification requirement. That's why Google must sponsor you and test the labor market to see if there is any other US person who can fill your job. You need to tell me more to, make the argument of why you are exempt from that ordinary requirement, right? So going back to that example, let's say you are an AI engineer, but not only are you working at Google, but you're also doing research on a particular way of training AI models that can, use less data and, help with more efficient training. It's kind of a new way of training the model. I mean, I know nothing about AI, but let's assume that I do. Um, Such that, it'll be groundbreaking for the field because if previously you needed, I don't know, like 10 terabytes of data to, train this model, now you need 1 terabyte of data to train this model because of this XYZ technology that you're developing. And not only are you developing this new technology, you are working on a patent for this technology, and you will be publishing this patent so that other companies will be able to license this technology and also improve the way that they are training those models. That can be a completely different strength of an argument with respect to meeting the first prong, substantial merit and national importance, because the government now can look at this particular project and assess what is the prospective impact of this project to the field. And that is really the operative question that you want to help answer. And you want to make sure that the government understands it very clearly. So, geographic scope is no longer the focus under Matter of Dhanasar. Your endeavor does not need to physically touch every single state in the United States in order to be considered something of national importance. Now, really, the question is, what is the prospective impact, and does it go beyond your particular employer or your immediate clients? So endeavors that have national or even global implications within a particular field, such as with improved manufacturing processes or medical advances, if you are helping to develop a new and more efficient treatment for a complicated disease. And if that particular medical advance naturally, will be disseminated through things like academic papers and conferences, and if it is best practices, of course, other doctors may want to also use, that kind of new treatment that you're developing, right? So any endeavor that is at the forefront of your niche, right? It doesn't need to be the entire field, but your niche, right? So that kind of endeavor can be said to have national importance because it will have that kind of impact to the field, in the field. So it is very important to consider what exactly are you proposing to do, and how can you prove that this will have such a broader importance to the field, as opposed to simply, using existing approaches and servicing clients, doing good business, doing good, services, but not going further than that. Really, you want to think about innovation. Really, you want to think about how you are going further than, what is already there, and really contributing to changing the field in a broader way. Um, let's see. Benefits must go beyond one's immediate employer or clients. We already talked about that. Substantial merit is the easier standard, but you must achieve both substantial merit and national importance. National importance is focused on the larger scale and broader impact of the endeavor, and you really want to think about dissemination of your work. How are the results of your work being disseminated to other experts in your field, other companies that are in the same field? How will, your advancements spill over to the industry more broadly in the United States and contribute to, a more general advancement of that particular niche? Those are the questions that you want to be asking for and putting to the forefront when you're making the national importance argument. Job shortage issues in the United States does not mean that the profession rises to the level of national importance. And an easy example here is pilots. A couple of years ago, we saw a huge surge of cases being filed with the argument that since the US has a shortage of pilots, anyone who is, proposing to work as a pilot qualifies for a green card under the EB-2NIW. And unfortunately, it was not true. It was really a myth. And it is quite unfortunate, because if you, file that kind of case based on a flawed understanding circulating through the internet, you would just get a denial, and that will impact your future applications in the United States. Really, those kinds of myths serve to, disadvantage, those clients in the long term. But yes, the It is important, not the importance of the field, but what you will do within the field. And we've, talked about this point many times, but it is really worth bringing home is that the impact of your project is what's important, not in which field you will be working. Similarly, the nature of your work when you're formulating your proposed endeavor can be very important. So I remember an AAO case, an appeal, um, where it was for a PhD person, an academic, who some of so the proposed endeavor was twofold. So one part of the PhD academics endeavor was related to teaching, because that's part of the job, and the other part of the proposed endeavor was with respect to researching a particular area and publishing research and presenting research in that area to advance that particular field. And the AO opinion actually separated out those two sub-elements of the endeavor. And in the opinion, we see the argument that the teaching part of the proposed endeavor did not have national importance because the nature of the activity of teaching only tends to benefit the immediate students to whom the teaching is distributed. Now, on the other hand, the part of the academics proposed endeavor that related to research and publishing research was found to have national importance because the results of this research would be disseminated to other experts who are also working at the forefront of that field and also impact their own research and their own projects and things like that. So a broader impact was seen in that part of the proposed endeavor. So really, it's important also to think about what is the nature of the proposed endeavor and how can you, argue your proposed endeavor in a way to point to a broader impact than just benefiting your immediate, customers or clients or your employer. All right, the second matter of Dhanasar criterion is that the case must prove that the applicant is well positioned to advance the endeavor. And here, the focus really is on the individual. You want to look at the applicant's background, relevant experience and education, and much care should be given to providing a good sampling of an applicant's record of success and influence in the field. That tends to work very well. Sort of think about it as a portfolio of your most impactful projects in the past. So if you have, for example, worked on R&D projects and actually published patents before, and have these patents been cited by other people, right? Or have you disseminated your research in conferences in the industry, things like that? Have you influenced your field before? And that kind of evidence can also inform the first prong as well in some way, saying that, oh, okay, this person already has a track record of influencing the field. Maybe what they're doing now will also influence the field in the future. So really, all the evidences and prongs kind of also tie in together in some way. But definitely the focus of the second prong is to show that you've already had a track record of success and influence in the field that is relevant to your proposed endeavor. How far along is the endeavor? So if you are an entrepreneur and let's say you are already in the United States on an E2 visa or any other visa or one visa, maybe things like that, and maybe you already have, had significant progress in your business project. If you're using a business project as your proposed endeavor, if you're preparing a startup, for example, and let's say you've received investment from venture capital funds, or if you've, went through a successful seed round or pre-seed round or something like that, those kinds of evidences can show that you're well positioned to advance the endeavor because you have already grown the endeavor to such an extent to have that evidence that U.S. industry actors are interested in supporting your work. It also, provides a little bit of independent independent evaluation of the merits of your project as well. So it's helpful in multiple ways. If you have, been seeing a lot of growth in terms of revenues and hiring, if you can provide tax returns, corporate tax returns showing those significant revenues, showing economic contribution to that particular region, or if you can show Forms W-2 showing a high number of jobs created in that particular region, that can also be very helpful in supporting an entrepreneurial proposed endeavor, showing that the track record is strong and you will keep growing your endeavor to maintain and create more jobs in that region in the United States. So those types of objective evidences can be very helpful in supporting your NIW petition. The third prong is that generally the evidence in the petition must show that on balance it will be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. So going back to some considerations for prong one, if your endeavor will indeed not only benefit a particular employer, not only benefit a business's particular immediate clients, but if it will end up advancing the field as a whole, or if it'll end up improving medical practices such that you will contribute to saving more lives, hundreds of thousands of more lives, improve public health in the United States, or things like that, improve the welfare of veterans in a broad way, right? Not only one veteran or two veterans, but really if you're, introducing novel programming that can, influence the way that veteran services is approached, right? Kind of a policy level, kind of a, larger field level impact in that way. Significant cultural contributions, for example. Those things can be used to support that on balance. It will be good to have the large scale benefits that this person can bring, as opposed to saving one job spot for one, US worker, right? So you can use those kinds of arguments. Leaning on some prong two considerations if you have very unique skills and know-how that really can't be replicated by someone who only has minimum credentials in the field. That can be another argument you can lean onto. So if you're knowledgeable in a very specific field of very specific area of, I don't know, building training algorithms for AI models, for example, which cannot be found in the general population of AI engineers, you can make that case and really lean on that by saying that having those know-how and technologies for the benefit of U.S. Companies and for the field as a whole would be more beneficial, than imposing the labor certification in that particular case. Finally, for entrepreneurs can also lean on the fact that in many cases, entrepreneurs have majority ownership of their companies and cannot easily avail themselves of the traditional labor certification pathway. Entrepreneurs can also use the fact if they are creating a high number of US jobs through their business projects, that in itself is a countervailing benefit of really the motivating factor of Congress instituting the labor certification process in the first place to, secure US jobs for US workers, right? But if you're creating a high number of jobs, you're already advancing those priorities by Congress. So many different ways you can approach the balancing test. Definitely work with a skilled lawyer who can help you formulate all of these, points in a strong way. One thing to note before we move on to the next slide is that Dhanasar specifically notes that entrepreneurial work can lead to an NIW and even states that the planned venture does not need to ultimately succeed as long as the applicant can show a plausible basis that it can succeed and can show the prospective impact will be, of a scale of national importance as we discussed earlier. All right, so one more slide before I'll hand it over to Dustin. Just a little bit more on national importance because that is increasingly being the linchpin of a successful NIW case. For national importance, you will need to prove the importance of the individual's specific proposed endeavor, not the importance of the field or occupation the individual will be working in. No matter how important AI is to the US government, if you cannot show that your work will be, particularly having a broad impact to the field of AI, you will have a bit of a difficulty. Expert letters can be a very important element in proving national importance because those experts can speak to the prospective impact of your specific endeavor. If you only rely on things like government pronouncements, kind of speaking generally about the importance of a particular field, those then it'll create a gap with, what is the importance of your particular endeavor, right? But the expert letters can fill that gap, discussing what your work will do to the field, as opposed to talking generally about the importance of a field. So expert letters can be a very important element in supporting national importance. Benefits to one specific employer alone will usually not be enough, and the government is looking for the expectation of broader impacts to a field, a region, or a public at large. So one example in the policy manual is that a person developing a drug for a pharmaceutical company may establish national importance by demonstrating the prospective public health benefits of the drug, instead of solely projecting the profits that will accrue to that particular employer. So that's one distinction you can make. And similarly, if you can show a widespread interest in adopting or licensing a technology that you will be developing, a novel and important manufacturing process that you will be developing, or how the technology stands to impact the development of similar technology by other companies, and the key word is dissemination here, you will have a better chance at prevailing in the national importance argument. Finally, one thing to mention is substantial economic benefit can be a basis to support a finding of national importance if you are an entrepreneur and if you can show that you will create U.S. jobs at a level significant with respect to a population or economy of a region. And we are talking dozens and dozens of jobs. We're not only talking about one or two jobs that you're creating. Really, the scale matters here more and more with these types of petitions, millions of dollars in revenues, for example. Then you may also be able to meet the national importance threshold. But all of these considerations are very nuanced. I highly recommend working with a skilled lawyer to really identify the strongest points for your case. All right, so
Great.
I'll turn it over to Dustin now.
Thank you very much, GA. So I am going to talk a bit about what's actually included in a national interest waiver submission. And this is all going to build on what GA has already shared with you all. But the question is, okay, so GA's laid out the actual requirements for an NIW. How do you actually show that in a petition? So with a USCIS petition, which is the first step in an NIW, you would file a Form I-140 with USCIS. USCIS does not accept original documents, so you're going to be providing copies of documents that prove that you meet the requirements that GA talked about before. So if we start with what GA first talked about, which was the threshold requirements, if you recall, you can qualify based on an advanced degree or bachelor's plus 5 years of progressive experience, or if you don't have that, 3 of the 7 criteria to show exceptional ability. So if you are qualifying based on your degree, you are fortunate because all you have to show is that you have that degree, a copy of the actual degree. If you're qualifying based on degree plus experience, you'd need to show the copy of your degree as well as signed letter copies of signed letters from past employers talking about your work experience and how it does cover that 5-year period and that it is progressive. If you are qualifying based on satisfying at least 3 of the 7 criteria for exceptional ability, this is where the documentation requirement can become substantial. It is generally a good idea to not limit yourself to 3 of the criteria. So what the government says is you need to satisfy at least 3 of the 7 criteria. But typically what USCIS will do is they'll say, thank you for providing evidence of the 5 criteria you've argued that you meet. We think that you actually don't meet 3 of those 5. You only meet 2 of them. So we need proof that you meet the 3rd. So if you limit yourself to 3 of the criteria, chances are the government's going to come back and say, we don't think you meet 1 of them, or we don't think you meet 2 of them. So you want to try to satisfy as many of the criteria as you reasonably think you can. And what I like to say here, and what I think is really important, is that this is your opportunity to really think broadly and to really advocate for yourself. Of course, your immigration lawyer, that is their job as well, but your immigration lawyer is not going to know if a newspaper article was published about you 7 years ago, or if you received an obscure award but a very meaningful award in your field. It is going to be up to you to sit down and think through your history, look at the different criteria, and say, you know what, I got that award 7 years ago. And I want to share that with my lawyer. I want to make sure they know about it. You know what? I was published in that magazine or that newspaper 5 years ago. I need to bring that to my lawyer's attention. So it really is your opportunity to, again, think broadly and really advocate for yourself and think about what evidence is out there that can be used to argue that you meet at least 3 of these 7 criteria. And to show how you meet these criteria, it really is going to depend on which criteria we're talking about. So let's go back real quick to what GA was talking about here. So exceptional ability must meet at least 3 of the 7 criteria. So official academic record showing you have a degree, diploma, certificate, or similar award. Letters documenting at least 10 years of full-time experience in your occupation, a license to practice your occupation or profession, evidence you've commanded a salary or higher compensation, membership in a professional association, recognition for your achievements and significant contributions to your industry or field by your peers, government entities, professional or business organizations, or other comparable evidence of eligibility. Okay, so let's say you are qualifying based on recognition of your achievements by your peers, government entities, or professional or business organizations. One of the common examples of this would be, for example, if you received a government grant. So let's say that you have an endeavor you've been working on, and the U.S. Department of Energy has issued you a federal grant for your work, for your research. That would be a wonderful example of this. So the evidence you would want included is proof that you were selected for this grant, proof that you received the grant, correspondence between you and the Department of Energy, for example. You're going to think broadly about how you're going to convince a government official that you actually were selected for this competitive and meaningful grant. So this is an area where the required evidence is really going to come down to the specific criterion that you are trying to meet. But really, what the takeaway here is, remember to think broadly. What is out there? What evidence is out there? And advocate for yourself. This is not a time to be humble. It really is a time to brag about yourself, to say, you know what, I got a grant from the government. You know what, I was recognized in this professional publication. Things like that. So let's return to our previous slide. You also need to include, beyond that you meet the threshold requirement, you need to include evidence that you qualify for the national interest waiver. So in this respect, I'm going to echo what GA was talking about. Dhanasar, the Matter of Dhanasar, that is our 2017 case that really provides a framework for how to qualify for a national interest waiver, really creates 3 key buckets. Your endeavor needs to be in the national interest. It needs to have substantial merit, and you need to show why the labor certification process should be waived. So let's set aside that 3rd bucket. We'll talk about why in a moment. And let's focus on those first 2 buckets. So how do you prove that the endeavor is in the national interest and of substantial merit, that you are the ideal person to pursue that endeavor? What evidence would you provide to show that? So let's focus on first that the endeavor is in the national interest and has substantial merit. This is going to focus on what it is you're trying to do. So you would look, and you have examples here on your screen. What has been published about your endeavor? This might be newspaper articles. This might be academic papers about your research. If you're an entrepreneur, this may be a very comprehensive business plan. It might be an economic report that's looking at the area where the business is going to be and the importance of the jobs that it's creating. you really do want to focus on objective, independent evidence. Okay, so this is going to be evidence that is out there that really a neutral party, so maybe a newspaper, maybe a magazine, maybe a government entity, a journal, for example, that is peer reviewed. This is objective evidence in these sources that is showing why your endeavor is of substantial merit and of national importance. Now, you see here on your screen the second bullet, expert letters. Expert letters can be critical in a national interest waiver application, but what I would generally say is that they are typically not sufficient. So what I mean by that is that you typically do not want to file a national interest waiver petition that is only supported with expert letters. What you want to use expert letters to do is to add context to your primary evidence and to support what the primary evidence is already showing. So what do I mean by that? Let's say that you are a researcher and you have been published in a journal that is very renowned in your specific field. If you were sitting in a coffee shop and you asked the person sitting next to you if they've heard of this journal, they're going to say no. But someone in your field knows that this journal is actually very well respected. That's a great example where what you're going to want to do is show proof that you've been published in the journal, so a copy of your article in the journal. But then you may want an expert letter from someone in the field who says this journal is actually very well respected in our field. Here is how often the journal is cited in our field. Here are the meaningful articles that have been published there in the past, some examples of that. Here is the circulation figures, how many people read this journal, things like that. So you see how the expert letter is going to support the primary evidence, which is the copy of the article. Contrast that to leaving out the journal article and just putting in the expert letter. That's not going to be very persuasive if an expert, even if it's a renowned expert, says this person, published an article in this journal which is well respected. USCIS is going to come back and say, well, show me a copy of the article. I'm not going to take you at your word. I actually want to see the article. So hopefully that explains how best to use expert letters. And there are kind of two categories of expert letters. What I've just described, it would probably be best to have an independent expert letter. So this is someone who doesn't necessarily know you personally, but they know the journal and they're able to speak to that. That can be very persuasive in that context. But there are also letters from experts where they do know you personally. This might be someone who, let's say, again, let's stick with our example of you being a researcher. This person might be a very high-level person at your university who is familiar with you, familiar with your work, and they're willing to say this person does outstanding work. That can be a very helpful expert letter, even if it's not independent. So think about those two categories. It's good to generally include both and to think about how the specific type of expert letter can be most helpful for what you're trying to show. Next, let's switch real quick. I've been talking about the endeavor mostly. Let's talk about the second bucket, which is why you are the ideal person to pursue this endeavor. So what you want to do there, again, don't be humble, think broadly. You're going to want to include evidence that shows why you really are the ideal person to pursue this endeavor. So that might start with a copy of your resume. It might start with copies of your degrees, proof of your past professional accomplishments, including awards, if you've been personally awarded grants, or projects that you've led in the past have been awarded grants. If you've been awarded a patent, that can be a wonderful example of why you, as an individual, are very well suited to pursue your specific endeavor. So this really can be broad. So again, think broadly, don't be humble. And again, it is, as GA mentioned, you want to focus on the field of your endeavor. So keep it focused in that regard and really think about what is showing why you are the ideal person, again, to pursue your specific endeavor in your field. I'll quickly talk about entrepreneurs. If you are trying to meet this as an entrepreneur, show proof of your track record. You can show past W-2s for your company. GA mentioned this. How many people you're employing, what your revenue, what your profit is from past tax returns. If you have received venture capital funding, that can be a wonderful endorsement. If the government has given your company a grant, maybe because your company is creating jobs in a socioeconomically distressed area, the government is supporting it. That is wonderful evidence. So there is certainly evidence that entrepreneurs can provide as well. I said before, set aside the third bucket. The third bucket is why labor certification should be waived. The reason that I say set that aside is because that bucket is usually satisfied through the other two. So if you show that your endeavor is of national importance and substantial merit, and that you are the ideal person to pursue that endeavor, usually it naturally follows that labor certification should be waived. Now, we in petitions make that explicit, and we will say because they met A, B, and C, labor certification should be waived. But really, in terms of the substance and what you provide in the petition, there's usually not much more that's provided to address that bucket. So let's talk about some recent trends. There has been a significant increase in the number of national interest waiver petitions filed in recent years, and probably related to this, the rates of requests for evidence and denials has also increased. That being said, our firm, we do regularly see approvals on national interest waivers, so these petitions are still being approved. You can look at government statistics that show that these petitions are still being approved with regularity. In terms of our firm, past results don't predict or guarantee future outcomes, but in this environment, in this immigration landscape, it is important to keep in mind these petitions are still being approved. Yes, there does tend to be more scrutiny. That may be because of more applications arriving at USCIS's door. That may be because the government is taking a more restrictive approach. But at the end of the day, these petitions certainly can still be approved. In the Biden administration in particular, there was guidance issued talking about what GA mentioned before, STEM, endeavors related to science, technology, engineering, and math, STEM fields, including AI. The Trump administration has, in certain instances, withdrawn this guidance, but that does not mean that you should not make the argument that if you are in a STEM field, that brings national importance and substantial merit. Just because the White House has withdrawn its own guidance on this or policy on this does not mean that there's not other evidence in the world that STEM fields are particularly important for the United States. So certainly still cite to that, and we would make those arguments still, even if we're not citing to White House guidance. Some entrepreneur-specific strategies. I've already mentioned some of this before. I would say that one of the most important things to know if you're applying as an entrepreneur is that it is difficult but not impossible to be approved based on job creation alone. What does that mean? That means if you are applying based on job creation alone, you do need to be creating a significant number of jobs. I would say several dozen would be the minimum. Your company should be generating in the millions in terms of revenue. But again, I'm talking, and ideally those jobs would be created in an area that really benefits from job creation. So you want to make those arguments if you are applying based on job creation alone. But one of the things that we would certainly work with our clients on is to think about whether there are any other aspects of the endeavor that are beneficial beyond job creation. So to give an example, we worked with a client who had created, he was an entrepreneur who created a number of jobs in the dozens. But what his business did was he, first of all, tried to focus on areas that were socioeconomically distressed, where creating jobs really did benefit the area, but also he really tried to focus on revitalizing certain businesses, certain buildings, and certain downtown areas. So he would work in areas that had an interesting history or culture, but had fallen on difficult times in recent decades. And he would work on building businesses in these areas that would celebrate the history and the culture of these places. So you have that cultural and historical benefit in addition to the job creation benefit and the economic benefit. And so by doing that, you kind of diversify the arguments you're making in your application. And I would certainly say, rather than relying just on job creation, try to think about what the other benefits of your endeavor are. Use letters from local politicians talking about the benefits of your business. Again, look at the economics of the business. You can't neglect that. Your business, if you're applying as an entrepreneur, the business does need to be promising and ideally will already have a track record. But if it doesn't, you can use a very well-developed business plan as well as an economic report from an economist talking about both the promise of the business and its idea, its concept, as well as the likely impact. So again, you do not actually need an operating business to apply for an NIW as an entrepreneur. But if you are doing that, you really do need a robust business plan and economic report at a minimum. And you really do need to show that you personally have a track record that will make USCIS believe that it is likely that even though this business has not been operational, we believe so much in this person and this entrepreneur that we really do think it is going to have the impact that this person says it will. So, real quick, I know we only have 5 minutes. What are some considerations when moving from a visa, and by visa we mean a temporary visa, a non-immigrant visa, to a national interest waiver? A national interest waiver is a green card. So the big difference between a temporary visa and a green card is that, by definition, a temporary visa requires that you intend to leave the United States at the end of your status, at the end of the visa. A green card, by definition, means you plan to remain in the United States permanently. So this can be tricky. Say you're in the U.S. on an E2 visa, which is a temporary visa. So you're required to leave at the end of it, and you decide to apply for a national interest waiver. How do you convince the government that even though I'm on a temporary visa and I'm applying for a green card, I still plan to leave at the end of my visa? It can be tricky. So what do you do? I will start by saying that this is done all the time, and it can be done successfully. So if you are in the U.S. on a temporary visa and you plan to apply for a green card, that can certainly be a viable path. It is important to work with a lawyer because there are some real risks in doing that you need to navigate. Right now, in this day and age, it is important to maintain your underlying visa. So we would not recommend that if you say are on an E2 visa and your I-94 is going to expire in a month, we would not recommend that you apply for a national interest waiver and not extend your E2 status. You need to extend your E2 status or leave and come back into the U.S. on an E2 visa so that you have that E2 status for as long as you can while the NIW, the I-140, is pending. And that's because right now the government is, in certain cases, taking action against people who the only justification they have to stay in the U.S. is a pending green card application. You really do need to maintain your underlying status. Again, that gets nuanced, that gets complicated. So talk with an immigration lawyer if you have questions about that. In terms of timing, so as I said before, the first step and I probably should have said this earlier, the first step in applying for a national interest waiver is to file a form I-140 with USCIS. Once that is approved, you have two options. You can either file a DS-260 with a consulate, which means you leave and get your immigrant visa at the consulate and then come back into the U.S. as a permanent resident. That's called consular processing. Or after your I-140 is approved, you stay in the U.S. and you adjust status by filing an I-485. That second option, adjustment of status, requires that you stay in the United States until you have a travel permit. And that's really where especially critical that you maintain your underlying status. If you're consular processing, it reduces some of the risk because you can make the argument that you have to leave the U.S. to get your green card and you're not planning to stay in the U.S. permanently. In terms of timing, there is an option to pay for premium processing, which is around $3,000. It will reduce the processing time for the I-140 down to 45 business days. And that is a significant reduction because the I-140 alone can take months, if not a year. Now, that is only the I-140. It's not the I-485 and it is not the DS-260. So you do still need to wait for a green card to be available to you before you can file either the DS-260 or the I-485. The way you find out if a green card is available for you is to look at the most recent visa bulletin. We are limited on time, so I'm not going to pull that up right now, but look at the visa bulletin for the second employment-based preference and see if your country of birth is listed and if it's current. If it has a C, that means you can apply for the green card now. If it does not have a C, it's going to have a date, and that's the date of the application that they're looking at now when green cards are available. And right now it could be, I haven't looked recently, I think it's about a year and a half to a year or so. Okay. Pros and cons of adjusting status versus consular processing. I've touched on this. Consular processing reduces some of the risk of the government accusing you of wanting to stay in the U.S. on a temporary visa. The downside of consular processing is you have to leave. You might be stranded outside the U.S. But if you're working with a qualified immigration lawyer, they can usually give you a good idea of how, of the risks involved there. And since you have an approved I-140 consular processing, you're probably not going to be stuck outside the U.S. But adjusting status does let you stay in the U.S. It does allow you to apply for a work permit, so you can work once that is approved. That can be filed with the I-485. So there really are pros and cons depending on your need to travel, your need to go back to your home country, or really any country outside the U.S., because if you adjust status, you abandon that application once you leave if you do not have a travel permit. I have shared a lot of information on this slide, but really the thing is that these are topics that are very situation specific. So if you think that any of this is relevant to you, it's important to schedule a consultation. These are very complex issues, and we need to understand your specific circumstances. So schedule a consultation to talk more about that. I am not going to go into the case study. You'll get a copy of this presentation. You can look at it, but this just echoes what we've talked about in this presentation through an example. And we are over time. We do have a question. Gia, I don't know if you had a chance to read this.
I
can.
I can answer this question. So, are publications, research work, journals, and citations critical for NIW? Are there chances for approval without this? And the answer is yes. The majority of the cases that we do are not traditional cases with citations and for academics. But we do look very closely at the client's other forms of dissemination of the results of their work. It is very important that, especially for people in the industry, right? It is very important to show how the work will benefit the field beyond just benefiting the immediate employer or the immediate clients. Press releases for the work, even if your name is not mentioned, can be very helpful. Things like, being featured in industry podcasts, being featured in industry newsletters, things like that. Be creative. There are other types of industry-specific thought leadership that can be very helpful in providing proof of impact, but you do need some evidence that your work will impact the field. It just doesn't have to be the traditional citations metric, the academic publication metric. We definitely work with a lot of entrepreneurs who use non-traditional forms of evidence, so definitely talk to us to discuss your particular field and what you could do, even if you're not in the traditional academic route.
Perfect. Thank you, Gia, and thank you to all of you for joining us today. Please do keep an eye out for our email. Schedule a consultation if we could be helpful at all. And in the meantime, stay well. We look forward to seeing you again soon.